Yes. Today's topic is what is meant by partition and what are the properties are involved in the partition. I think you understood what I am telling. Hello?
Yes, sir, we can follow you.
Yes.
Yes.
Right. Now, always two properties are available. One is joint family property. Another one is ancestral property. Another one is self-acquired property. These are the three properties are available for partition. If the self-acquired property wants to be thrown into common stock, then the said property is also for partition. Now, if the self-acquired property stands in the name of any member of the family, if that property purchased from the joint family fund, that is also called as joint family property. Just you think how to ascertain which is the joint family property, which is the ancestral property first. Then you go for further. First, I want to take ancestral property means the inheritance by way of succession from several ancestors are left the property without any document and acquired through the partition, acquired through the inheritance, acquired through the legal heirship. Those properties are called as ancestral property. Then joint family property, what it means? The father is acquired, died leaving behind immediate their legal heirs. That is called as joint family property. I think you understood the difference between ancestors and the joint family property. Joint family property, always it is only one legal heir, one step. Those who are acquired the property among the father has acquired and leaving behind his children, wife and children, they are entitled equal partition. That is called as joint family property. And now two differences are there. Ancestral property always coming from the inheritance from forefathers, or always it is divided among them and everything has been earned. Now, these two properties are always available for partition. The third property is available also for partition because any family member purchase the property arise out of joint family fund. Kindly maybe look into the word joint family fund. If that property is earned from the joint family fund, purchased in the name of one of the family member, definitely it can be thrown out into common stock and that property is also divisible. That property is also subject matter of partition. Then somebody is an employee of our family and he used to maintain all of us, stating that I am going to look after because I got employment through the joint family fund. Therefore, I want to look into. But he was purchased the property during his tenure of service. If his intention, he wants to put this property into common stock, then it is also partition. It is also subject matter of partition. If the intention is very clear, if that person wants to keep this property is also through the common stock, means ancestral, joint family property, and self-acquired property. All the properties are mixed together and effected the division. Definitely, the properties are subject matter of partition. Then, now, recent burning problem. I think you know very well. The woman right has been confirmed on 2012-2004. Date may be noted down. Women's right has been confirmed on 2012-2004 with effect from 1/1/2005. She is also equal right along with the male member. The word, I think we are also using always one word, stating that kotta hennu kulakke horakke, because once she married, she is losing everything. That is the word. So therefore, this fact has been brought in the amended Act of Hindu Women's Right has been given under Section 6 of Hindu Succession Act. Hindu Succession Act. So Women's Right has been confirmed. Hindu Succession Act as on 2012-2004 with effect from 1/1/2005. So now landmark judgment is there. That is Vinod Sharma versus Rakesh Sharma, AIR 2020 SC 3717. Note down this one. Reported judgment of Honorable High Court of Karnataka, Vinod Sharma versus Rakesh Sharma, AIR 2020 SC 3717 page number. So in that decision, how it has been, history of the judgment has come over before the Honorable Supreme Court. Various high courts are passed the judgment. Our own Honorable High Court of Karnataka, Prakash versus Phulavati case. Prakash versus Phulavati case, it was decided the date of birth. Those who are born 1956 onwards, they are having right to claim equal right against the male member. Then death of the father prior to 2006, they cannot claim any partition. So likewise, decided by our own Honorable High Court, our Lordship Justice N. Kumar, is remarkable judgment. It was started and it was scrutinized the section 6, how it is eligible for entitlement of property by the woman. So therefore, it was decided by this Honorable Court, date has been given and death of the father is taken into consideration and partition took place prior to this. They cannot claim. All this aspect has been decided by the Honorable High Court of Karnataka. First judgment it was started scrutinizing the section 6, whether woman is entitled by birth or not. This is one thing. And women are when they are entitled. So that is also described in the present judgment, that is Vinod Sharma versus Rakesh Sharma case. So what it happened now in this case, by birth itself woman is entitled for equal partition, provided prior to, because there is a provision has been made, provided that how she is entitled. The Karta of the family sold the property, some of the properties prior to 2012-2004. Those properties are not subject matter of partition. And another thing, and partition, if registered partition took place, estoppel has been made out, stating that on whether the woman is a co-partner of the family or not. So co-partnership has been decided in the said section, that is 99/2005. Those who are co-partners means they are also family members. Who are the family available, the members are called as co-partners, and those co-partners are also entitled equal share from 9/9/2005 onwards. This is also laid down in the said judgment passed by Honorable Supreme Court. Now, you see the joint family property, ancestral property, and the self-acquired property, throwing into common stock, purchased from the joint family fund, all these facts to be ascertained while you are getting the claim before you, how the fall of the title has come to him while he is claiming the partition. So fall of the title you should be ascertained prior to drafting the partition suit. So my request is to you all, how to ascertain those documents, because several documents prior to mentioned in the sale deeds, how vendor is having a title to the property. Now, whatever the properties are allotted under the partition, womb in the child means child is in the womb is also entitled equal partition. That is the law behind it. Because under partition, if the father has got married and child is in the womb, and he is also entitled equal share along with the other members. So this is the word has been used in the joint family properties and ancestral properties. So therefore, you have to ascertain first while getting the document from the client and preparing the partition suit. So therefore, whether the property has been thrown into common stock, that is also ascertained. Whether the property has been come from ancestral, you should ascertain. And also joint family property means immediate father died, leaving behind his properties, that is called as joint family property. That is also be ascertained. And another thing, the Karta's duties and liabilities is there. Karta of the family is the father or mother. If Karta has sold the property for the purpose of marriage, for the purpose of legal necessity, for the purpose of discharge of liability of the family, those sale deeds cannot be questioned. That is the law. But the party, if you want to question whether as on the date selling the property, there is a serious liability on the person who is a karta of the family, if that is so, if sold the property, then he has to prove, or the other person shall prove, stating that yes, there is a liability of the family, therefore the said property has been sold. It can be ascertained from the document itself. So legal necessity must be there, legal debt must be there. That is only for the pertaining to the joint family, but not any other thing. So likewise, you should ascertain while preparing the partition suit. Nowadays, you see, yesterday one case came to me. Third generation coming before me stating that we are having ancestral property, but only male members are got it affected the division. So how we are entitled? So I have told them, stating that the third generation, whether their father continued or in joint possession, or they are co-partners, these two ingredients you must be ascertained. Then only you have to drop the partition. Otherwise, it is very difficult for you, stating that without ascertaining this fact, you should not drop the partition suit. So all these facts for clearance of partition, which are the properties involved, which are the properties are required to be partitioned. So now, if the partition was took place under the suit, you must remember, being a advocate, probationary advocate or budding advocate or coming advocate, you must understand, wherever partition suit is filed, preliminary decree has been passed. What is meant by preliminary decree under partition suit? This is only preliminary decree. He is entitled of share from the properties, which are properties are available in the judgment. So preliminary decree is not going to confirm your possession or your property. Where a property is available, it is do not know by passing the preliminary decree. Therefore, you have to file once again for seeking for partition. Seeking a partition, house if it is available, the executive engineer of concerned jurisdiction, he is to be partitioned. Or if the house is not unable to get it partitioned, it shall be sold. Only by selling, the whatever proceed arise out of selling, it shall be available for partition. Then that is finality, it comes. Finality, how it comes? Only after sale deed executed by the court or executed by the other family members to purchaser, then proceeds shall be deposited before the court and shall be withdrawn, or proceeds can be taken from the party itself. This is pertaining to house developed properties. And pertaining to agricultural land is concerned, as per order 20 rule 18, the agricultural land shall be effected division only through appointment of deputy commissioner or the then collector. So therefore, the deputy commissioner only having power to effect the division, and he can delegate tahsildar or surveyor only on assessment. If the property has been divided, now I am entitled for 1/5 share. 1/5 share shall be assessed by the government revenue authorities and fix the taxes and put him into possession. That is the duty of deputy commissioner pertaining to the agricultural land. Under order 20 rule 18, it is finality. That is, when final decree proceeding initiated for effect of division, you should ascertain about this. Otherwise, it is very difficult for you. And yesterday I read one judgment. Under the preliminary decree, whatever preliminary decree has been passed, it is finality and distributed the division wherever they want. It is not final. Only in FDP proceeding, ascertained by the appropriate authorities, then only the partition is complete. So these are the pertaining to the suit for partition of joint family property, ancestral property, self-acquired property, purchased through the joint family fund, and all these facts you must be ascertained. And final decree proceeding, if you want to read AIR 2012, page number 1856, SC. AIR 2012 SC, page number 1856 shall be read for how the final decree proceeding going to be complete. So these are the decision and several decisions are available with me. If you want, you come over my office, you collect those decisions relating to the ancestral property, joint family property, and all. And under the partition suit, you have to question about the sale deeds, which are third party interest created to deprive the right of the joint family member. So therefore, you have to take advantage of this, stating that the joint family property has been sold, our ancestral property has been sold, where our right is available, and such properties of sale deeds, and the party should be heard, whether he is a bona fide purchaser or not. That party should be made as a party to the proceeding. And all the one condition I want to tell you, partial partition is not available in the IF law. One property is sufficient for us for getting partition. No, all the property should be brought into the suit. Joint family property or ancestral property or any property if you want to claim. All the property should become. And parties also the same thing. Parties should be ascertained from the genealogy tree called as Vamshavraksha. So therefore, parties should be ascertained, and all the parties who are entitled share, they must be necessary and proper parties to the suit for partition. So these are the precautionary things you should be make out and file a suit before the court. That's all. Any question, you please ask me.
Sir, how it could the self-acquired property, how it can be proved that it is funded from a joint family?
Sir, one thing, I have purchased the property in my name at my native place, and proceeds which was arrived from purchase of the property, my father has given some amount. Mother is also contributed towards that said amount, but I have not stated anywhere else. But what is my right during the purchase of the property, and what is the fund available with me, because I am unemployed. I have purchased the property. Where is my income is available to show that this property is purchased from my income? So that type of evidence you should collect and ascertain about the ownership of self-acquired property of a joint family member. Yes, sir.
Sir, there is a one case like in the year 2005, in the month of May, the property was sold. It's an ancestor property where there is no consideration is given, and ancestor properties so 2-3 properties has been sold to one third party. Which is belonging to an ancestor property. Now, actually, the co-partners they didn't got the, share in this. I mean, the women, 2 women did not get the share in an ancestor property. Now they are claiming, is it possible, sir? But that there is no consideration given. But there is
Immediately you have to file
Yeah.
application under under Order 7, Rule 11. These properties are void ab initio or not for entitled for partition based on Section 6 proviso. That is the word has been used 2012 2004. Prior to any property sold, those properties cannot be brought into partition by women.
Okay.
Yes, yes, sir.
But sir, you said by birth, women has got the right.
Birth they have got right, but effected from.
Okay.
Effected from, that is the proviso. By
Okay,
birth, if the partition was not took place among the brothers, And whatever the property has been sold prior to that, those properties are not available. But remaining property available, if partition was, see, one example I am providing you.
Okay, sir.
The olden days, between
sir.
brothers, they are getting the partition in writing. Unregistered document they are placing before the authorities. And those unauthorized, unregistered document is also mentioned in the Vinod Sharma's case. It cannot be recognized document. It is created by themselves, depriving the right of the woman. So therefore, those documents cannot be taken into consideration, and for which you can entitle. But it must be what happened. The act came into force 1/1/2005.
Okay, sir.
The properties are several properties are sold by the male members which are allotted under unregistered partition deed after 1005. When the cases were started, they have alert, and those properties are also entitled for partition because unregistered document prepared for the purpose of selling this property. So likewise, you have to ascertain.
Okay, sir. Okay.
Like this.
Thank you, sir.
Sir, good morning. Hello.
Yes, sir.
Sir, what are the rights of children, daughters, who, how do they claim the property of a mother who's been legally separated from them, sir?
Sir, mother's property, section 14 and section 8 of Hindu Succession Act, it is dealt. Mother, if having acquired for the purpose of maintenance, by way of will, by way of purchase the property on her own income, you should be ascertained. So therefore, mother's property, if individual property is available, it cannot be bring into for partition. Because law is very clear for the woman property is concerned.
And what if the property is given by her parents, sir?
Parents also, if given, if gift has been made to her, if love and affection, it has been provided during the course of marriage, all these properties are self-acquired property only of a woman. You have to establish whether this property has been given, what purpose they have given, all these things. Now the wife, the woman is coming before the court for partition, and brother has taken defense, stating that the marriage expenses, huge expenses I have made, and huge gold articles I have given to her. Therefore, she has relinquished her right to claim any partition. That is the defense taking by the persons. Those are decided long back. No, why it is duty of the family member. Such being the case, you maybe spend huge amount by selling the property. Does not mean that you have allotted any partition, allotted the property under partition to her, and you got it the relinquished right. That is the release deed from her. So that type of defense is available for the women.
Sir, is there some time limit? Let us say father passed away, so they'll have rights for 50,
No,
60
sir,
years.
just this is the broad line. 2004, that is 2012-2004, it is barred to claim any property prior to this. And this is the restriction has been made. And always she is entitled equal share along with by birth itself. By birth itself, if the only brother is available, there are 5 women children are available. If those 5 women are not effected division by only one brother, then they are entitled equal share along with him, 1/6 share.
Sir, my grandfather died away intestate. He didn't write any property to anyone. Like in 1973.
Yes.
Now, can my Attendru come and ask the property.
Yes, definitely. Today, I told you, no, yesterday come over, third generation of property. Third
Oh.
generation means the Mommakkalu from the great grandfathers. They are coming before me and asking me, we have not got any property from my mother, because my mother is one of the co-partner to their family. Therefore, we are entitled for equal share.
So this Adverse Possession Act and
No,
Time
adverse
Limitation Act.
possession already declared in respect of joint family property or ancestral property is concerned, it is lost, sir. No adverse possession can be claimed.
So this limitation period of 20 years for land, is that not applicable yet, sir?
Sir, under the Partition Act, there is a limitation 3 years. 3 years. Within 3 years of demand, they shall file the suit. But that 3 years cannot be taken into consideration only in partition suit. Limitation cannot be taken into consideration because property's right has been given by birth itself. How we are going beyond the limitation? That is the question already decided. Limitation is not applicable in partition suit, even though under Article of Limitation Act, only 3 years.
Okay, sir. Sir, grandmother died in the year 1960 or so, and she had four children, including daughters. But after her death, her brothers has taken possession of the property. So after close to 50 years, can their children, including the daughter, claim the property now? And they have
Now also, if the partition was not took place among them, without her presence, she can claim.
okay, sir. But there are
And
legally-
whatever property is sold, it cannot be claimed. If property is available, she is having a right.
Okay,
That is
okay,
the
sir.
word has been used in the judgment of Vinod Sharma's case.
Okay, sir.
Right.
Sir, if after 2004, if the property is sold, and whether she can claim from that, sir?
Not
The
brother.
partition?
That is woman's only, not brother. Suit for partition, he has to prove. This is only women purpose, madam. Section 6, which is amended, women purpose. Now you are asking me, one of the brothers sold the property. They are entitled equal for partition. They have to file questioning the sale deed and whether he is a bona fide purchaser or not. It is burden lies on the purchaser.
So
What
who
is
has
this bona
purchased
fide
has to
purchaser
compensate,
means
sir?
what, sir?
Huh?
Bona
Bona
fide
fide purchaser means, now you see, he is having a liability. That is one of the person who got the partition without presence of the woman or another brother. Then there are 3 or 4 properties are available, and whatever share available for him under the joint family property, that portion shall be allotted who has sold the property. That is called as bona fide purchaser, and he cannot be denied. This property is for partition and this property is liable to equal partition. If one property is available, equal partition, he is going to lose the other portion of the property. One property if it is available, and several properties are available, then the whatever alienation made by the first party among the 5 members, that all the properties shall go to whatever property he has sold to him, and other properties remaining, and more properties if he has sold, then he has to come to other properties also.
Sir, relinquishment of rights from a lady, so means there are two sisters and one brother.
Yes.
Now it's a joint family property. The
Yes.
2 sisters have given a relinquished deed, means they have released deed they have done.
Yes.
Are their sons capable to challenge?
No,
such-
no, sir. No, sir. No, sir.
Okay.
No, sir.
Sir, if a partition is not made, when the partition had to happen, now some land is remaining. None of the brothers are there. Their children can challenge, sir, the daughter's children.
Yes,
They can challenge now.
they can.
Whatever remaining property is there.
Yes, sir. Yes, sir. Yes,
Okay, sir. Thank you.
sir. Right.
Sir, when giving relinquishing, let us say one brother and two sisters are there.
No.
Like sister one and sister two, can they separately relinquish, or they should be jointly? They should relinquish.
Jointly or separately, they can execute the relinquished deed. It must be registered.
Like
Because
one can release saying that I don't need any share in the property
Yes,
on
yes,
one day,
yes,
and
yes,
a week later the other one can relinquish like that.
yes. And just this is the point inward in this case, because always I am fighting in this regard. Relinquishing right of the property should be in favor of whom? Whether whatever share I am entitled, it shall be relinquished in favor of A. That is first brother or second brother. My right should be given to him. That type of relinquish is available. And her share only. Her share only, it can be relinquished by her in favor of anybody else. Or I don't want to take any property from the joint family. Let them divide all the equal, including my share. That is also there.
So they can say one to one or one to many also.
Yes, 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 yes.
Okay, what is the difference between relinquish deed and partition deed is like they're distributing the property among themselves, right, sir?
Yes, under partition deed also, we can relinquish our right. I don't want to take any partition. I don't want to claim any partition. It is also, you can relinquish the right under partition deed itself, because she is also party to the partition deed. She must be a partitioner. She must be a party to the partition. That is registered part. And one thing, whatever the partition deed took place in the year 1996, because 1996 onwards, there is a direction from Honorable Supreme Court. Every partition deed shall be registered. So therefore, whatever it may be, even otherwise relinquishing, but unregistered relinquished deed cannot be accepted in the IF.
Sir, in the self-acquired property, if it is gone into the common stock,
Yes.
on a later date, can it be reversed back, sir?
No, 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 no. Once it was thrown into common stock, it is always joint family property or ancestral property.
It cannot be reversed in any way.
No, 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 no. It cannot.
Okay.
Until and unless accepted other party.
Means relinquishing.
Yes, yes, yes.
Okay.
Sir, registered relinquishment deed means it has to be registered in front of sub-register office. Sir.
Yes, yes, madam. Yes.
The
Sir, what
person
will be
who is
the
relinquishing has to go to the sub-register and should
Yes,
sign
yes,
there, sir.
definitely. The party must be there.
Okay, sir. Not just writing in a paper and giving.
No, 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 nothing, nothing, nothing.
Okay, sir.
It can be questioned by the children of person.
Okay, sir.
Yes.
So does children need to also permit, or only the lady is enough, sir, to relinquish?
Sir, head-wise, sir, one family head. One, now you see, we are 5 members. And our children are available. When head is available alive, so therefore 1/5 share it can be allotted.
Okay, so they'll be able to relinquish if
Yes, 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 yes.
What will be the, is there, what is the approximate charges, sir, for relinquish deed?
Sir, this is nothing. I tell you, within 5,000 it can be complete. Mere relinquishing deed. I don't have any right against the properties of so and so joint family property. That's all. It is within 10 or 15,000. There is a charge of registration and all these things.
Sir, in
And
case of death
if
of
you,
one
if
of,
you, if you are valuing the property, then you are liable to pay. Hmm.
Sir,
Sir.
one more question, sir. One already sale. I mean, already sale has done. Sale deed has done,
Hmm.
and that part, that co-person, means like he doesn't have any sons or daughters. He's unmarried. That anyhow already can he write a will to any person?
Yes, it is self-acquired property of her. If don't
No,
have
it's
any
an ancestral
children,
property, sir.
if
It's an
even
ancestral property.
ancestral property allotted in her favor, though she is not married and no issues to her, automatically she is entitled to sell the property. That is the section 14 of women, right?
Yes, sir.
Yes.
Thank you.
Sir, without proper partition, if the person has one co-person has sold the property and the other has to get their rights, they haven't got, whether they can go for partition for that which is already sold property, sir?
Yes, madam, always, because by questioning the sale deed, purchaser should be made as a party and you must establish it is a joint family property, alone cannot be sold. But one thing is available between brothers. If the elder brother sold the property, being a karta of the family, he can alienate for the purpose of something. But it is burden lies on elder brother to prove that it is legal necessity. Therefore, I have sold the property while we are in joint possession.
Sir, who has to compensate here, sir, if it comes vice versa, like whoever has purchased or whoever has sold has to compensate, sir?
Purchaser only a property, if half of the property entitled by him, another brother.
No, like some the outsider has purchased the property. So
Yes, madam, it is burden lies on him also. He has sold the property. I have paid consideration amount to him, but he must prove that it is for the purpose of family I have sold. Otherwise, it is very difficult for the purchaser also.
okay, sir.
Okay.
Okay, thank you, sir.
Welcome.
Sir, in case of three sisters and one brother, if one
Yes.
of the sister is expired
Yes.
and a balance three are there, the other two sisters have given the relinquished deed. Now the relinquished deed, can the children of the dead sister can come, sir?
Now, when now section 6 came into amended, just you think over that, that is the date for the line.
Before
One date
that,
has been given 2012-2004 onwards. If anything is happened, equally entitled by their children are also.
okay, before 2012,
Yeah,
2004, it
it is
cannot be
not
challenged.
possible. It is not possible, sir.
Okay,
So
sir,
now
thank you.
children have to relinquish, right, sir? If that.
Yes, if it is available, they have to come. They have to come. Otherwise, they are going to file a suit on behalf of our mother. Now, third generation persons, they are coming before the court because of Vinod Sharma's case only. By birth, right has been given.
Sir, is will probate mandatory, sir?
Sir, relating to the agriculture land, I have already told about the will. Probate relating to the agriculture land is must. And I think you know the letter of administration or letter of administration is required, the house properties and all these things. Probate is concerned, agriculture land is must, and then only the landmark judgment is available in by our own Honorable High Court of Karnataka, stating that pertaining to agriculture land, probate is must, and they should get the title to be effected in the revenue records.
So now, let's say grandfather is written will to grandson. Now, let's say the will is probated. The registration charges also will apply, right, sir?
Yes, at the time of drawing the probate, not before that. After completion of your evidence, that matter will be sent to collect the fees charges as per law. That is the decree going to be drawn after the evidence proved through the will and everything. And you must know that whether it is a self-acquired property of him, how it has come, ascertained from him. And one thing, just you keep in your mind, even the karta of the family or the elderly person can bequeath the property by way of will, effecting the division, whatever property allotted to him, effecting the division to his children, the will can be drawn. He need not get acceptance from any children. That is also available. That law is accepted.
Sir, will is valid only on registration, no, sir?
Yeah, no. It need not be registered. It be registered, it may not be registered. But only for proving document, piece of document should be proved. Just landmark judgment is available of our own Honorable High Court of Karnataka. One evidence, whatever signature has been made by the executing the will authority, that shall be proved through one witness. That is the landmark judgment of Lordship Justice Kumar.
So the witness of the will, sir,
Yes.
he must be a witness of the will.
Witness of the will. And if though both witnesses are not available, you have to bring their children or made known to them as if the Mallaya signed. Yes, Mallaya, I know. He is a permanent resident of this village. And he used to told me, stating that I have signed as a witness. So he can bring and give evidence for ascertaining about the signature of witness who has signed for the purpose of bequeathing the sum of the properties in favor of their children. And he signed the document for which Mallaya has signed as a witness. Some of the witness made known to Mallaya, he can also bring as a, but subject to the cross examination. How we know what are the, because suspicious circumstances always should be proved.
So in case of thumb impression, sir,
Thumb impression also, you have to bring from sub-registrar office, comparing the thumb impression from bring and other authenticated document. Means this is the thumb impression is belongs to so and so, and same thumb impression is available in registered document, because if the will is not registered, thumb impression is there. That thumb impression shall be proved another registered document.
okay, thank you, sir.
So basically, if a will has to be passed, property has to be handed over through will. One thing is there will be probate charges, right, sir? Like all the charges on probating the
Yes,
will.
probate you have to file, sir, relating to agriculture land only, not other.
Yeah, and after that again we have to go to sub-register, and then we have to stamp duty registration charges.
No. That is not already court going to collect that. Probate issuing only by court, not the sub-registrar.
Which means sub-register has to
No, it need not be registered, sir. Because the original will getting surrendered by the court and issuing the probate order and collecting the charge by the court.
Then
And
sub-register has
original
to
will
valid-
is not available for you.
Sir?
Original will is not going to hand over once the probate has been issued by the court.
Okay. So sub-register, how will it enter into the documents? Because who will pay the
Only you
sub-register?
you can request to the court to permit him to get it registered.
Oh, okay.
Okay.
How many days will that probation process will take, sir?
Sorry, on filing of you were able to process, because paper publication you have to take immediately filing the probate proceeding. Then paper should be filed before the court, and no respondents are available. It is burden lies on you. if the court is directed to lead your evidence, prove the will, then you have to subject matter of the will to be proved by way of witnesses. It is your process, sir. Those who are interested to lead along with the court, and every day today you have to attend and get it done. Within 3 months also we can get, no problem, provided the court is having the time to get the.
Okay.
Yes, is there any question relating to the partition and everything? I think you have learnt all these joint family property, ancestral property, self-occurred property, throwing into common stock. Common stock means whatever properties are available along available ancestors or joint family property, along with those properties, are if it is divided, it cannot be treated as self-occurred property. So therefore, all these things available for you. And whenever if you want, you come to my office and collect the drafting as well as the decision on which available.
Sir, in case of joint family property, how do you recognize it through any document, sir, that particular property
There are
is
no
of common
documents,
stock?
sir. You see, sir, the sale deed, father has purchased the property, father died, leaving behind without intestate. So automatically it is joint family property.
Oh, in that way, we got to assume.
Yes, sir.
Okay.
Thank you then. Shall I close now?
Yes, sir. Thank you.
Thank
so
you,
much.
sir.
Thank you very
sir.
much, sir.
Welcome, sir. Welcome,
Thank
sir.
you. Thank you, sir.
Thank you very much, sir.
Well-
Thank you, sir.
Thank you, sir. Thank you, sir.